Okay.
So good afternoon and welcome to another one of our webinars. It's James from Community Legal Centres Queensland here. Can I begin by acknowledging the traditional owners of the lands on which we're dispersed. There are people tuning into this webinar from across Queensland, from across Australia it seems. So I acknowledge the traditional custodians of all of the lands across Australia and particularly acknowledge elders, ancestors and any Aboriginal or Torres Strait Islander people who may have joined us for the webinar today. Welcome to you, welcome everyone. I'll hand over to our expert presenter, Jodie Woodward, in just a couple of minutes, but before I do, I might just deal with a couple of housekeeping type things. I emailed around a copy of Jodie's PowerPoint to most of you a couple of hours ago, but I know a few extra people have registered. You can also access the PowerPoint from our website, and I've posted a link to that in the chat section of the GoToWebinar control panel that you've got, or in the handouts section. You can find it as well. We're hoping to record the webinar and make it available on our website, and we'll email a link around to everyone when that's done, assuming that the technology works on that, which isn't always the case. A couple of ways that you can ask questions. You can ask a question by typing a question into the questions box. The other way that you can ask a question is to press that button that looks like a hand. If you type a question into the questions box, I'll shout out and paraphrase it or read it out directly, and Jodie can answer. Or if you type something into the question, if you raise your hand, we'll be able to unmute your microphone and you'll be able to ask the question that way. Can I suggest you hold over your questions until the end of the presentation, though webinars and kind of conversational stuff don't work particularly well, so we might hold them over until the end of the session. They're the housekeeping type things. So without further ado, I guess I'll hand over to Jodie Woodward, who's a solicitor at North Queensland Women's Legal Service, to present to us on social media and family law. Thanks, Jodie.
Okay, thank you, James, and good afternoon, everyone. Thank you for attending today's Community Legal Centre Queensland webinar titled Social Media and Family Law. As James said, I'm a solicitor employed by the North Queensland Women's Legal Service, and I'll be your presenter today. Now, just before we commence the webinar, I just need everyone to have a read of the disclaimer that's shown on the screen. And I need to remind you that any information provided today is not legal advice and should not be used as a substitute for legal advice. The information in today's presentation is accurate at today's date, which is the 30th of January 2017. Okay, so North Queensland Women's Legal Service is a community legal service for women run by women. We are funded by the state and federal governments, and we provide free legal advice, information and referrals to women, mainly in the areas of family law, family or domestic violence, child protection, child support, sexual assault and discrimination. We can provide face-to-face appointments in Townsville and Cairns, and we also provide monthly outreach services to Atherton, Mareeba, Innisfail, Mossman, Port Douglas, Ayr, Ingham and Charters Towers. And we also provide assistance via telephone and Skype, and we encourage women to use our 1800 legal advice line, which currently operates Monday through to Thursday from 9 AM to 1 PM. So today we will be looking at social media and how it can be used in relation to family law matters. We will specifically look at the ways in which social media has enhanced the practice of family law, such as through its use in serving documents, but we will also examine the risks associated with the misuse of social media for both clients and for legal practitioners. Okay, but first we will examine service. So as a rule, documents in family law proceedings require special service, which means the court must be satisfied that the person has received the documents. There are generally three ways the court can be satisfied of that. The first is that the documents have been delivered by hand using a process server or another person who is not a party to the proceedings but who is over the age of 18. Via post or electronic communication such as email, but this method requires the person being served to sign an acknowledgement of service and return it to you. And the third way is service on a lawyer representing the person being served, as long as the lawyer has previously agreed in writing to accept service. Rule 6.04 of the Federal Circuit Court Rules 2001 states that nothing in Part 6 of the rules, which relates to service, affects the power of the court to authorise service of a document in a way that is not provided for in this part. So it is possible for a judge to order service via social media, such as through Facebook Messenger. However, they will only do so when all other avenues of attempting to locate and serve a person have been exhausted. Service via social media cannot be used without a specific court order permitting service in this manner. So in the matter of Byrne and Howard, and the details of that case should be on the slides, the applicant asked the court to make an order allowing substituted service via court documents on a respondent through his Facebook page. The applicant provided the court with evidence that all other avenues of service on the respondent had been exhausted, and the court also believed that it was likely that service could be effected using Facebook. In these circumstances, the judge made the order for substituted service of court documents on the respondent through his Facebook page. Now, this case has shown that when asking the court to make an order allowing for substituted service, the following things need to be established in your affidavit material. So I've listed those on the screen. Firstly, that reasonable steps have been taken to attempt to serve the documents, that the proposed method of service is likely to bring the existence and the nature of the documents to the attention of the person being served, the extent to which the person to be served could become aware of the existence and the nature of the documents in question by other means, such as advertisements or some other method of communication, the likely costs of the applicant and the proposed substituted service, the proposed substituted service being a cost-effective method, and why the discretion should be exercised in favour of granting the substituted service. Now, the court must be satisfied on the evidence that the person who created the relevant social media page is indeed the respondent, that the social media page was in fact the profile of the respondent, that the respondent regularly accesses their relevant social media account, and that the respondent would reasonably get notice of the relevant documents if a private message or an email was sent using that account. So that is service. The next topic is publication. So according to Section 121 of the Family Law Act, it is an offence to publish any account of proceedings or images that identify people, including children, involved in family law proceedings unless a publication order has been made or another Section 121 exemption applies. If found guilty of such an offence, a person may be fined or imprisoned for up to 1 year. They also leave themselves open to being charged with an indictable offence. Now, in the case of Lockie and May, the father and his family made derogatory comments about the court, the ICL, the expert witnesses and the mother in relation to family law proceedings on social media. He also revealed confidential information about the case. Federal Magistrate, now Judge Neville, found that the father had breached Section 121 and ordered that the father and his family remove from Facebook all references to the court proceedings and prevent him or his family from publishing further material relating to the proceedings, the mother or the mother's family. He also ordered that the Australian Federal Police be provided with a copy of the order and were asked to monitor the social media activity of the father and his family for a period of 2 years to ensure that they were complying with the court orders. It was further ordered that if the father or his family breached the orders, the matter would be referred to the Australian Federal Police for prosecution. Now, Section 121 sub 3 of the Family Law Act states that without limiting subsection 1, an account of proceedings or any part of the proceedings can be taken to identify a person if it contains any of the following particulars. And I have listed some of those up on the screen. I won't bother everyone with going through them all, but basically if someone is discussing the proceedings or even an account of the proceedings but don't specifically name the parties, it doesn't necessarily mean that they will be safe from breaching Section 121. Simply by naming details such as characteristics, clothing, relatives, or even using the sound of their voice, such as on a televised broadcast, it could be enough to identify someone, and therefore they could be in breach of Section 121 and be liable for up to 12 months imprisonment. Also, Facebook posts, tweets, or even a select group of friends could still be a breach of Section 121 because the Act does not actually impose a minimum threshold of what comprises a section of the public. Now, I'll go through the recent decision of, and it is an unusual name, but I believe it's Guarez and Vitella. Now, in that case, Justice Forrest noted that the publication of material online is quite different to the publication of material in a once-off publication, such as a newspaper article. In this case, a mandatory injunction was made issuing the father to remove material from his website that referred to family law proceedings he was involved in, including the names of the parties and other identifying material. In granting the injunction, Justice Forrest noted the particular insidious nature of the material, given that it was published on the internet and remained accessible to anyone, anywhere, at any time. So it really is important that legal practitioners ensure that their clients are provided advice about Section 121. Clients should assume that everything they post on social media is public, including posts on other people's social media pages. If they need to vent, they should do it to close family or friends in person or on the phone, but not over Facebook or social media. And it might be an idea to go through their Facebook friends and delete any of them whom they're no longer friends with. It's also a good idea to tell clients to monitor their privacy settings, but don't rely on them to protect your client. At the end of the day, it is the responsibility of your client what they do on social media, and it's always better simply not to post anything inappropriate in the first place. So that is publishing. The next topic is destroying evidence. Now, as officers of the court, we cannot counsel or suggest or even recommend to a client, nor should we be the party to a proposal by the client to destroy or remove documents, whether paper or electronic, that may be required in litigation. Now, the Queensland Law Society's Ethics Centre released a paper on this titled The Duty Not to Counsel or Assist a Client to Destroy Documents on Social Media. It refers to Section 177 of the Legal Profession Regulation of New South Wales, which outlines the rules placed upon Australian legal practitioners not to destroy a document or give advice to a client to destroy a document that could be required in proceedings, regardless of whether the person intends to actually commence those proceedings. Now, Mr. Stafford Shepherd, who is a senior ethics solicitor of Queensland Law Society, says that although Queensland doesn't have the equivalent provision in our Legal Profession Act, he is of the opinion that it reflects the ethical standard that would be expected of a legal practitioner in Queensland. He further refers to sections of the Criminal Code, specifically Section 129 regarding damaging evidence. I'll just go back. Section 129 regarding damaging evidence and Section 140 regarding attempting to pervert the course of justice. So nowadays people use social media to keep in contact and retain information, and the information exchanged or kept on those sites may be relevant to issues in dispute before the court. The family law rules provide that the duty of disclosure applies to all documents in a person's possession or control relating to relevant issues in the case. However, the Family Law Act and the Family Law Rules are silent on the meaning of document. So the definition of document in Section 2B of the Acts Interpretation Act is quite broad, and it defines document as any record of information. So practitioners need to be aware that clients could be tempted to destroy, delete, or remove documents that may be unfavourable to them. But as legal practitioners, we cannot escape the fact that our first and foremost responsibility is to the court, and therefore we must be careful when we're investigating and or supervising the disclosure process. So if a client doesn't give us information that we think we need, or insists on swearing an affidavit or delivering a list of documents which we know to be imperfect, or we have reason to think it may be imperfect, then we may have an obligation to withdraw. Similarly, we can't counsel or tell clients to clean up their Facebook pages or other social media accounts. And if a legal practitioner is found to have engaged in these types of behaviours, they could face disciplinary proceedings for unprofessional conduct. I would suggest that lawyers should revise their discovery request precedents to include a request for social media content. There's a feature on Facebook known as an activity log, which basically lists all of somebody's activity on Facebook. So it may be a good practice to ask clients for both theirs and the other party's activity logs. So the slide has already moved itself, but the next topic is evidence. So the Evidence Act does apply in family law matters, except when its provisions conflict with the Family Law Act. Therefore, judges in family law proceedings exercise their discretion when determining things such as the nature of the evidence required, which witnesses are to be called, how evidence is to be adduced, and what evidence is inadmissible. According to Section 55 of the Evidence Act, evidence that is relevant in proceedings is evidence that, if were accepted, could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceedings. Evidence is not taken to be irrelevant only because it relates to the credibility of a witness, admissibility of other evidence, or a failure to adduce evidence. So in family law proceedings, particularly in children's matters, I'm just going to go through some examples of where certain things may be admissible. So the first one is the suitability to parent. Now, social media can be offered to provide evidence of a person's or of a party's suitability to competently parent. And unfortunately, parents sometimes use social media to denigrate, profane, or use derogatory language towards another parent. And this can actually be used as evidence as to the suitability of the person who posted the comment. So one case example is the matter of Santoro and Santoro. Now, in this case, the use of social media by a mother to post negative comments about the father, which was likely to be seen by the children, resulted in federal magistrate finding that her postings of the message showed a lack of judgment and a disregard for her parental responsibilities. And in this case, the social media evidence ultimately had an impact on the matter in the issue at the trial. Another case is that of Reedby and Meadowbank. And in this case, the biological father of the child was challenged with examples of drug and alcohol using behaviours which was present on his social media account. He'd posted a comment that said, and I quote, "Coke is always good after a big night of drinking. I agree, both the powder and the liquid." Now, Justice Small was concerned about the post and that it intended to, quote, indicate a certain recklessness and immaturity on the part of the applicant. In that case, orders were made prohibiting the father from using drugs or alcohol prior to, during, and during his time with his daughter. The next example is where evidence is used to show intention or knowledge. So social media can be used to show that a party intended to, for example, relocate with a child, or on the other hand, that one party had previously provided consent to a relocation. An example of that is in the matter of O'Shea and Michaels, where evidence of a Facebook entry by the father indicated an intention to unilaterally relocate with his new wife and the child. The next is where evidence can be used to show a relationship, such as to show that a parent had a good relationship with a child. It may also be useful in shedding some light on the strength of the relationship by showing the frequency and the nature of contact between individuals. A case example for that one is Longsdorf and Granger. And in that case, evidence of a relationship between a mother and her new partner was obtained from Facebook, and it was relied upon in that case, despite the mother saying that basically what is on Facebook is not real. In that case, Federal Magistrate Harman made the comment that at the cross-examination of the mother in relation to her Facebook comments, he said it caused more embarrassment and the look of dread on her being caught out than I have ever seen on a witness's face. The next one is evidence to show family violence and or harm. Now, social media has been adduced to provide evidence of family violence and threats, for example, by an ex-partner or their family. In the matter of Edwards and Granger, the mother was fearful for the father's was also fearful of the father's family based on their repeated threats to her life on Facebook. And in that case, Justice Benjamin decided that these fears were not unrealistic, and he decided that no contact between the father and the children should be ordered. Evidence can also be used in some cases to show, for instance, the welfare of the child. For example, where some Facebook post by a child suggests that he or she is considering self-harm, or where, for instance, they're missing their school friends. An example of that is in the case of Hunter and Harrow, where copies of a child's Facebook entries expressing a desire to stay with the father on a weekly basis were tendered by the father. However, based on discussions with the family consultant, the child made it clear that whilst he may have said that to his father, it didn't reflect his true wishes. So this is a case example of a situation where the evidence from social media was not found to be a true representation of the view of the writer, and it serves as a reminder that the relative weight given to the social media evidence will be adduced in accordance with the circumstances of the case at hand. The last example is evidence that provokes the question of credibility. So social media can be used to discredit something that a party has previously stated. For instance, in the case of Doolan and East, a father posted a picture of some casino chips on his Facebook page with the caption, "Robbing Star Casino 2011." Despite his assertion that he'd previously said that he had not gambled for some time, this resulted in a finding that the father was an accomplished and facile liar. So the more relevant question in family law matters is not really whether the evidence will be used, but what weight the court will give to it. And this will depend entirely upon the nature of the evidence, and it is a matter for the discretion of the judge dealing with it on the day. Some people argue that due to the wide judicial discretion, the outcome of each case can turn on its facts, and therefore it is very difficult to predict outcomes. However, where evidence is not relevant in proceedings, it may not be admissible. For instance, relevancy is discussed at Section 56 sub 2 of the Evidence Act. And also when deciding whether evidence is inadmissible, it is also important to look at Section 135, which is the general discretion to exclude evidence. And the Evidence Act states that the court may refuse to admit evidence if its probative value is substantially outweighed by the danger that the evidence might be unfairly prejudicial to a party, or be misleading or confusing, or cause or result in an undue waste of time. So in the matter of Vecchi and Vecchi, the father asserted that the mother was more interested in following her social interests and going out drinking with excess with her friends. He told the court that he had obtained this information from her Facebook page, and Federal Magistrate Brown made the following remarks, and I quote, "I really do not care what people put on their social media, on their Facebooks, to be frank. I suspect that, like photographs, Facebook entries may reflect a mood at the moment which is transitory. You can have a photograph of a very happy child, and after the photograph is taken, the child is unhappy. But the thing about Facebook and photographs is that they just reflect a moment in time, and people act up for the camera or for the computer. I think it would be unwise for me to act on the basis of what people put on Facebook." One last thing would be to question the admissibility of the evidence by challenging the authenticity of it. And for that, you would look to Section 58 of the Evidence Act. So in conclusion, social media can be quite a dangerous tool for separated parents who use it irresponsibly. When an author posts something online, they lose control over the content, and it becomes accessible to countless people. And even after a person has deleted a comment or a photo from their social media, it may have already been copied or saved by another person, and unfortunately the damage is already done. So as practitioners, we need to warn our clients about the risks of social media and the need to think twice before posting online. So I'll leave it open to questions if James wants to monitor that.
Terrific. Thanks, Jody, for a really sharp summary of some of the crossover issues in family law and social media. A reminder, folks, that there are a couple of ways you can ask questions. You can press that button that looks like a hand on your control panel. We'll unmute your microphone and you'll be able to ask a question through your microphone, through your phone or your computer. The other way that you can ask a question is to type something into the questions box. And someone's done that already, Jody. The question is, and you might need to take this one on notice, but the question is, what can one do when their Facebook profile and or email is hacked by the other party?
I'm not sure about that, and from the context of a family law perspective, I mean, I suppose it will come down to obviously proving that that has happened, but I may need to get, practically speaking, look into that and get back to you about that one.
Terrific, thank you. So we'll take that one on notice. Thanks for your Esther. Another question that's come through, Jody, how does the position of solicitors not being able to give advice about not removing any derogatory Facebook posts to our clients sit if the other party intends or has flagged that they would be seeking an order that it be removed, which was, as our questioner notes, the case in Lackey and May, which is one of the cases that you talked about? So how do you square we can't advise to remove where the other party's flagged an intention to seek an order that something be removed?
Yeah, well, I suppose at that point in time, it's obviously, if there's a court order saying that something is removed, then obviously our first and foremost obligation is to the court, so we would be complying with a court direction in that circumstance. But I think more the issue is really just being careful to tell people to clean up what's on Facebook, because at the end of the day, you're ultimately destroying evidence. I mean, you can tell people, your clients, to be careful what they post on social media, and there's a big difference between doing that and telling them to delete things that are on Facebook. I think it's really making them accountable for their actions, because at the end of the day, it falls to them.
Terrific. Jodie, we've had one of our correspondents, Mark, post a link to some information from the Institute of Criminology about hacking offences. So I'll post that in the chat section of the GoToWebinar, and also post a link on our website that hopefully will deal with that question from Hester that we talked about earlier. So Leah's asked a question, Jodie, about service, and that flagging that contravention applications have particular rules in relation to service, and whether the kind of general points that you made about service in the the general points that you made apply specifically to service in contravention proceedings.
Yes. Okay. Sorry, was that a question?
Yeah, that's right. So the general point that you made about service, do they also apply to the specific service rules around contravention applications?
Right. Okay. I must admit I didn't look into contravention applications, but I definitely can have a look further about that and get back to the writer of that question. Thank
you. I should flag, if anyone out there knows the answer to that question, feel free to send it through. A question's come through, Jodie. Are you aware of any cases where someone's been prosecuted for publishing affidavits in a matter before the court? So, I mean, the non-publication point that you made before, and you flagged that it was an indictable offence, I think. Are you aware of people being prosecuted?
I didn't find any specific case examples about that. The only, obviously, that case that I discussed regarding Lockie and May, where matters were sent to the federal police, where they would be prosecuted if they were then in breach of a certain court order, but I did not find any specific examples of where someone actually had gone to jail for it, to be honest. Yeah.
Questions have been coming through quick and fast, but a reminder that you can ask questions by punching something into the questions box, and as I have been doing, I'll read it out and get Jodie to comment on that. The other way that you can ask a question is to press that button that looks like a hand on your control panel, which Sibel has done. Sorry, I'm just unmuting Sibel. I hope. Sibel, can you... No, you're typing in a question there. Sibel's asked, what is the extent of a lawyer's obligation to go through a client's Facebook page, which may contain thousands of entries? So you made the point before that you could seek copies of activity logs, or alternatively just go through a Facebook page. And so Sibel's question is, how much should we as lawyers be obliged or accept responsibility to go through information?
Well, I mean, I suppose it comes down to, again, relevancy of the material. So, I mean, you do have that duty of disclosure. If you think you might have some concerns about a particular client and things that they may, have posted previously, then I suppose it depends. It's up to you as to how far you go. But it's always a good idea to just have it there in case something hairy comes up later down the track that you weren't aware of. I mean, I'm not telling people that they need to go through and trench through 10 years worth of people's Facebook posts. Not that Facebook was around back then, but I think you're going to have to assess that on a case-by-case basis, really.
Thanks, Jody. Jessica Brake from the Mackay Community Legal Centre has made the point that the service requirements as they relate to what we've been talking about, that is using social media, are the same for contravention applications as they are for other forms of applications. So thanks, Jess. Jess has also asked a question, Jody, asking if you can take screenshots on Facebook, retain that, but delete the derogatory post.
Well, I certainly wouldn't be advising a client to do that. I think from the perspective of yourself, if you've got the evidence that you can rely upon at a later stage, then at least it's there. But again, you really need to be careful when advising clients to destroy, because essentially they're destroying evidence. So, I mean, it's quite a difficult one to answer, isn't it?
Absolutely. So there's a bit of a theme coming through in questions on this. So the next one's come from Louise, who asks, if your client has already published on Facebook and tells you, so in breach of the prohibition on publication under Section 121, should we advise the client to delete the Facebook post to prevent further and ongoing publication, or would that be destroying evidence?
In my opinion, that would be destroying evidence. Again, I mean, how people, it's an ethics question really, how people read this is up to them, but you can see from the material that it is considered destroying evidence if you're suggesting to clients that they delete things from their Facebook page. I mean, you can talk to them about how important their public image is, and I suppose it's the way that you frame it to the client as well. But you need to be very, very careful for your own ethical and professional obligations that you aren't actually telling them to delete something.
As I said, there's a real theme on this. Another question's come through, or a suggestion saying that you could use the hide function on Facebook, so it's still there and still available, but might not be able to be seen by certain groups depending on your privacy settings. Someone else has asked, if a Facebook post is deleted by the other party, what is the procedure to obtain access to it if it's been derogatory about your client? Do you subpoena Facebook, or are there other options available?
Wow. I may have to get back to the writer of that. I'm actually not sure what the answer would be for that. I suppose it's difficult because once it's deleted, unless someone's taken a screenshot or a copy of it, how would even the person who put it on Facebook, you know, get a copy back? I'm not too sure whether even Facebook would be able to troll through their records. Yeah, I'm not too sure about that.
So if anyone's had any experience trying to subpoena or otherwise get records from Facebook, please let us know here. Rebecca, you've got your hand raised.
Yes, I do. Hi, how are you going?
Yeah, good, thanks.
Good, thank you.
Thanks, Jody, for your presentation, and I'm really intrigued by the whole discussion about Facebook content as a piece of evidence or material that's subject to the duty of disclosure, and then the predicament that you're in if a client breaches the prohibition on publication. I guess less of a question, more of an observation, just having heard some of the other questions and thought it through. To strike a balance between the duty as a lawyer that you've been talking about, I guess my question is, would it be sufficient to keep an evidentiary record of the publication, but counsel your client to delete that publication so there's no ongoing breach of that provision, but the evidence is still preserved?
Yeah, I absolutely it is a difficult one. I suppose I think the other question was, in that particular case, there was an order in place saying that that had to be taken down. So in that case, yes, you do need to comply with the order, but then keeping a record of it, obviously. But in other matters where there is no order, are you then, you know, disposing of evidence?
Yeah, and I think how it plays out, at least in my experience, is that, and I've certainly had clients who have skated very close to breaching the rules around non-publication and on Facebook, and they'll be the first to concede once they're advised that well, they weren't aware of that, or that advice you gave them not to do that might have gone in one ear and out the other, and that they're happy to remedy it. So if it was to play out in a scenario where their conduct was brought to the attention of a judge in the course of the proceedings, that they'd probably readily concede that yes, that occurred, and so there'd be no real need to bring any evidence because they'd readily concede that it happened, and that it might be to their credit then before the judge and in the course of litigation for them to be able to say, look, I've acknowledged that I've done the wrong thing, and I've done something to remedy that, and I didn't need a court necessarily to give me an order to do that. You know, can I have a gold star, please?
Yeah.
So I guess it depends too on the seriousness of the breaches, but I've found that clients, once you point out to them that, you know, look, that's a bit too close to the line or that's inappropriate, they'll self-correct their behaviour if they've got some insight. And in some ways that's a really positive thing for the post-separation parenting relationship if it's going to be salvaged, and there is going to be an ongoing co-parenting relationship, which is an element of, or factors in sometimes, I think, to the advice.
Yeah, I think you do just have to really tread that fine line between, you would hope that your client would realise for themselves upon having a stern conversation with them, perhaps that they do need to be careful about what they're posting, and perhaps then they may have the foresight to then remove it without you actually telling them to remove it. Do you know what I mean?
Yeah, exactly. Yeah. Yeah. Thank you so much for bringing it up though, because it's very an interesting sort of area that we deal with more and more.
Yes, I know.
You can mute me now.
Thanks, will do. Thanks, Beck. That was great.
Thank you.
Michael, you had a question or a comment as well there? So Michael's suggestion is to take it down, then repost with denial of access to all, which preserves it on Facebook but is not published. I'm not sure that would get around, necessarily get around it. Another suggestion that's been made is that hiding a post doesn't delete it, it just stops the publishing of it, which means it can always be removed and might strike the balance.
Yes.
So I guess there are some different perspectives on this, and another comment that's come through, Jody, and I don't know if you'd want to comment on this, is that our participant here would be concerned that leaving a derogatory comment up could potentially open up other cans of worms like defamation, depending on the nature of the comment.
Yeah, absolutely. And again, it's very difficult because obviously you need to counsel your clients, but at the end of the day, you don't have a lot of control over what it's their Facebook page. You're just trying to help them navigate through what could potentially impact upon their case, and you would, like I said, you would hope that once you pointed that out to them, that they would be wise enough to take it down themselves without you having to actually, breach that obligation you have by telling them to actually destroy it.
Gee, it's a minefield. Jody, thanks so much for helping us navigate our way through it. On behalf of the many people that tuned in this afternoon to hear about social media and family law, can I thank you for your presentation, which was very thoughtful, as I said before, very direct and clear. Can I thank everyone who logged in today to listen to Jodie and to participate in the conversation, which has been really thought-provoking. We're hoping to have a recording of this up in the next day or so, and we'll email around a link to that. If you've got any other queries, please feel free to send them through, noting that we can't provide legal advice but only generalised information. If you've got any suggestions about future webinars, please let us know as well. There's a whole program of about another 15 over the next 4 or 5 months. So we'll look forward to you tuning in to those. Thanks, Jodie. Thanks, everyone, and have a good afternoon.
Thank you.